The Hispanic male?
Stand by. I got people in the car on the way right now.
Probably the same guy from yesterday. You might see them making out and stuff. You're in for a show.
Hi everyone, Ed, not AI, here, and here's the latest in the Donna Adelson case. Donna Adelson defense attorneys remain busy. They will be deposing Wendi Adelson in Austin, Texas on March 21st. Also, they filed a motion in limine seeking to exclude or limit the admissibility of the court file in Wendi Adelson and Dan Markel's divorce case. We're about to read you the pertinent portions of the motion, but let me share the commentary first. Generally speaking, the motion is a good one. It seeks to prevent the improper admission of the information in the court file. The arguments are cogent, well made. The motion acknowledges that in the past, the court file was admitted on argument by the prosecutors that the information in the court file goes to the issue of motive. It was offered to show the state of mind of the defendant and the motive in the case. And to us, that issue properly identifies why, ultimately, most of the court filings should be admitted. This is not the first time we saw a similar argument. At Charles Adelson's trial, the issue came up during Wendi Adelson's testimony. Wendi was claiming that the family was not worried about the post-divorce litigation. She mentioned that her mom wasn't even aware that Dan Markel had filed a motion seeking to limit Donna's contact with the children. Georgia Kappelman, however, was able to impeach her testimony on that issue, showing an email that Wendi sent to several people, including her mother, with a copy of the motion. That is our recollection, at least. Generally speaking, to us, the entire court file, or at least the most important portions regarding Wendi's efforts to move with the children to South Florida, and all of the post-divorce litigation are highly relevant and are being used not to prove the truth of what is in those files, but what was going on, what motivated Donna Adelson and the others to first come up with legal but disgusting ways to force Dan Markel to give up his efforts to keep Wendi in Tallahassee, and what ultimately led one or more Adelson family members to go with the hitman option. There is no false narrative, as the defense suggests, by the prosecution on this issue. Although Dan Markel and Wendi Adelson had agreed to equal time sharing of the kids, there were ongoing issues about the kids during the divorce and after. During the divorce, the issues were so contentious that an independent coordinator was appointed. There were ongoing issues about Dan seeing the kids via Skype, about diet, about schooling, about many, many other issues. The motive for the murder of Dan Markel vis-a-vis Donna involves her desire to be close to the kids in South Florida, her desire that Wendi and the kids move to South Florida, her desire that Wendi no longer have to deal with Dan Markel in coordinating parental decisions, in sharing the children, etc. Sadly, this was a murder, in our opinion, that was done because some in the wife's family, Wendi's family, thought that the husband, Dan, was insufferable, that his supposed litigiousness which in our opinion went both ways, and his insistence on strict adherence to his parental rights as secured in the marital settlement agreement made life with Dan around too difficult for the Adelsons. The prosecution's argument, based on all the evidence, which includes the issues that arose during and after the divorce, is that Dan was killed to reverse the effect of the marital settlement agreement, to reverse Dan Markel's win in the divorce battle over the kids and Wendi moving to South Florida, and to ensure that the post-divorce litigation was never ruled upon by the court, but instead became moot by Dan Markel's passing. Therefore, everything that happened in the divorce is highly relevant, and it helps make sense of why Donna was writing in her emails to Wendi about how to deal with Dan Markel's objection to her desire to move to South Florida. The post-divorce litigation does not have as strong a connection to Donna Adelson, at least per the publicly available evidence. There are no emails from Donna to Wendi about how to deal with those motions, to our recollection, but the evidence is that Wendi and her parents were very close. We believe that there will be evidence that the post-divorce motions were shared with Donna. There is evidence of Donna communicating with Charles Adelson about a gift for Harvey, and there is a direct connection between the timing of the murder and things that were happening in the post-divorce litigation. We have revealed before that Wendi Adelson had been set for a deposition in the post-divorce litigation, and that deposition was canceled because her attorney withdrew in May of 2014. The post-divorce litigation was therefore delayed by the need for change of counsel, including the hearing on the post-divorce motions, and the murder happened during that delay, before Wendi could be set for deposition, and before the hearing that involved accusations against Donna could take place. There is additional evidence that supports that for Donna, this was all about Wendi and the kids moving to South Florida. They got an awesome apartment, and right after the murder, Wendi and the kids went to live there, spending most of their time with Grandma Donna. We simply don't see how the court would exclude the most pertinent documents from the court file from Donna's case. They are highly relevant, are not being offered for the truth of what the documents say, but are being offered to show motive and state of mind. All right, here is the motion. In the Circuit Court of the Second Circuit in and for Leon County, Florida, State of Florida v. Donna Adelson. Defendant's motion in limine. Court file from dissolution of marriage. Defendant Donna Adelson, by and through her undersigned counsel, requests that this honorable court exclude the court file in the dissolution of marriage case Adelson v. Markel, Leon County case number 2012 DR 2240, and in support thereof states as follows. 1. Mrs. Adelson has been indicted in this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. 2. The state has listed as Exhibit 60, quote, divorce filing, unquote, indicating their intent to admit the entire court file in Adelson v. Markel. 3. By this motion, Mrs. Adelson moves to exclude and or limit State's Exhibit 60. Discussion. 4. Although Section 90.202(6) Florida statutes permits a party to ask a court to take judicial notice of court files, footnote, and pursuant to Section 90.203 Florida statutes, judicial notice is mandatory for matters identified in Section 90.202 when Section 90.203 is complied with. The contents of the court file and the documents contained therein must still be admissible. The contents must be relevant. Additionally, documents which contain hearsay are still inadmissible. 5. In Stoll v. State, the court held that, quote, although a trial court may take judicial notice of court records, see Section 90.202(6) Florida statutes, it does not follow that this provision permits the wholesale of admission of all hearsay statements contained within those records. We have never held that such otherwise inadmissible documents are automatically admissible just because they were included in judicial judicially noticed court file. To the contrary, we find that documents contained in the court file, even if that entire file is judicially noticed, are still subject to the same rules of evidence to which all evidence must adhere, end quote. 6. The divorce file contains over 560 pages. It is significant that Mrs. Adelson was not a party to the divorce proceedings. 7. There can be no credible argument that the vast majority of documents have any relevance to this proceeding. By way of example, summons, notices of unavailability, motions in order for telephone testimony, notices of depositions, requests for production, responses to requests for production, notices of filing deposition, manuscripts, deposition transcripts, orders directing mediation, notices of mediation, mediator reports, notices of hearing, notices of subpoenas, affidavits of service, Leon County Court Clerk receipts, report of dissolution of marriage, motions to reduce time to respond to notices of production, resignation and order terminating parenting coordinator, designations of email address, motions and order for substitution of counsel. 8. The only significance the undersigned can fathom is that the state desires to use the size of the divorce file to support their false narrative that the divorce was bitter custody battle. Footnote. The term custody was replaced by the term time sharing by the Florida legislature effective October 1, 2008, by operation of Chapter Law 2008-61, in part because the term custody has been criticized as unnecessarily negative and outdated. Footnote. Rather, an objective review of the court file reveals that it is simply a dissolution of marriage between two well-educated professionals involving minor children and assets. Neither party alleged abuse or neglect, such that one would have a basis to seek majority time sharing. 9. Those documents which comprise the majority of the exhibit do not survive a relevance analysis in any way. 10. In seeking admission of the divorce file in previous trials, the state has asserted the statements contained in a certain filings, footnote, namely Mr. Markel's March 26, 2014 counter motion for enforcement of MSA on parenting issues and motion for contempt and sanctions, motions and his various filings for February 20th, 2013, May 2nd, 2013, January 20th, 2014, February 14th, 2014, April 11th, 2014, and May 14, 2014. Contained in certain filings go to motive of the defendant then on trial. Although such an argument could overcome the relevancy issue addressed above, the state must still establish their admissibility as either an exception to hearsay or as non-hearsay. 11. Regardless, the state of mind exception to the hearsay rule does not extend to the admission of the divorce file in its entirety. 12. Significantly, the state of mind of the declarant is the subject of the exception in Section 90.803, paren 3 Florida statutes, and it applies solely to the declarant's state of mind rather than the state of mind of defendant. 13. For example, in Bailey v. State, the defendant's first-degree murder conviction was remanded for a new trial because hearsay statements of the deceased victim, which tended to establish a motive for the alleged crime, were obviously offered to prove the state of mind or motive of defendant, a purpose for which the hearsay exception created by Section 90.803, paren 3, paren A, Florida statutes does not apply. With respect to Mr. Markel's March 26, 2014 counter-motion for enforcement, footnote, the state has previously referred to this 16-page motion, not including exhibits, as the mother-in-law motion. A little over 1 page of this 16-page document, plus the prayer for relief, concern Mrs. Adelson. There is no relevance to the remaining pages of this motion. Even if any of the remaining issues are relevant, they do not survive a Section 90.403 Florida statutes balancing, as their, quote, probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. The motion contains 8 specific requests. Only one of these requests applies to Mrs. Adelson, namely, the motion identifies statements allegedly made by Mrs. Adelson to or in the presence of her 3- and 4-year-old grandchildren. Her 3- and 4-year-old grandchildren later allegedly repeated those statements to Mr. Markel. 15. Statements purportedly made by Mrs. Adelson are admissions, however. Statements made by her grandsons to Mr. Markel are hearsay. The statements in Mr. Markel's court filings are also hearsay. Section 90.805 Florida statutes requires the proponent of the statement to assert valid exceptions for each level of hearsay to render the statement admissible. 16. With respect to the alleged statements repeated by the 3- and 4-year-old grandchildren to Mr. Markel and which Mr. Markel placed in the court file, there are 2 levels of hearsay the state must overcome for the documents to be admissible. Even if there is an exception for one level of hearsay, there is no exception for the second level of hearsay. 17. In Nowak v. State, the court reversed the defendant's second-degree murder conviction where the trial court permitted a detective to testify to what a co-defendant said the defendant stated about shooting the victim. The court recognized that what the defendant said to the co-defendant was an admission. However, there was no valid hearsay exception to allow the detective to testify to what the co-defendant said to the detective. 18. The state has previously argued that Mr. Markel's statements in the court file were not hearsay pursuant to Section 90.801, paren 1, paren C, Florida statutes, because they are not being admitted for the truth of the matter asserted, but rather go to the defendant's motive. Simply stated, the statements go to the state of mind of the listener. 19. In such circumstances, statements by Mr. Markel in his countermotion and other filings would not be hearsay to establish Mrs. Adelson's state of mind if the state can establish Mrs. Adelson knew the statements had even been made. Blackwood v. State. Victims' statements to the defendant were relevant to establish the defendant's motive. Eugene v. State. Victims' emails to the defendant were relevant to demonstrate the email's impact on the defendant. And 20. Absent evidence establishing Mrs. Adelson was aware of Mr. Markel's March 26, 2014 countermotion, the state cannot admit that motion as substantive evidence in Mrs. Adelson's trial. Footnote. The Nowak court also held that even if the detective could testify to what the co-defendant told him, the testimony was not substantive evidence of Nowak's guilt, but rather impeachment evidence to attack the co-defendant's credibility. As a result, the state improperly argued in closing that the statement was substantive evidence of Nowak's guilt rather than just impeachment of the co-defendant. Thus, any purported statement made by Mrs. Adelson to her grandchildren, as well as Mr. Markel's request to prohibit Mrs. Adelson from having unsupervised time with the grandchildren, cannot be admitted as substantive evidence in her trial. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this motion in limine, enter an order excluding and or limiting admission of the court file from Adelson v. Markel, Leon case number 2012 DR 2240, for such further relief as is just and proper. Certificate of Good Faith Conference. The undersigned certifies that he emailed Assistant State Attorney Georgia Kappelman and Sarah Dugan an advance copy of this motion on March 10, 2025. They object to the granting of this motion. Certificate of Service. Signed, Jackie Fulford. Signed, Joshua D. Zellman. Notice of taking deposition. 2. Georgia Kappelman and Sarah Dugan, Assistant State Attorney. Please take notice that the defendant, Donna Adelson, will take the deposition by oral examination of the person named below in person, with the state appearing via Zoom. The deposition will take place at the Legal Connection, Inc., Austin, Texas, 78735. Name, Wendi Adelson. Date and time, March 21st, 2025 at 10 a.m. Eastern Standard Time.